All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw an eye, give their attention to the court, now sitting.
Please be seated. Good morning and welcome to the Kansas Supreme Court. And Paul has brought his own cheering section with him this morning. So we welcome all of you. It's nice to see all of you, and welcome to everyone else who is here this morning. I'll ask Mr. Doug Shima to please, the clerk of the Kansas Appellate Courts, to please call the morning docket.
Thank you. The first case on the 9 a.m. docket for Thursday, February 2nd, 2023 is appeal number 124169, Alex Fisher versus the Kansas Department of Revenue, Johnson County, briefs both sides.
The court, Justices Tricia Bath, on behalf of appellant Alex Fisher, we are here and prepared for argument.
May it please the court, New Win on behalf of the appellee, Kansas Department of Revenue. We are present and ready to proceed.
Second case is appeal number 122660, State of Kansas versus Ron Richard Larsen Jr., Johnson County, briefs both sides.
Okay, please the court, Corey Call, appellate defender representing Ron Larsen Jr., present, ready for argument.
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas, present and ready for argument.
Your Honor, that concludes the 9 a.m. docket for today.
Again, welcome to everyone who is here in the courtroom, but also we welcome those who are watching through the YouTube channel today. I think probably those in the courtroom are aware that Justice Sandridge is recused from both of the cases on the 9 o'clock docket this morning, but to make that point clear to those who may be on YouTube. What it means when a justice recuses is that they do not sit and hear the oral arguments, nor do they participate in any way in the discussions or the deliberations of the court regarding the case. So the decision in this case, these two cases, will be made by the 6 remaining justices. So those of us who are here to hear those arguments are familiar with the facts of the case, read the briefs of the parties, as well as other portions of the record or and the legal authorities that are necessary for us to understand the arguments that the parties have made. We look forward to engaging with an exchange with the attorneys to help us better understand their arguments. And so all of you understand, we do have computers or papers in front of us. We will at times be looking at those. We may be looking at our own notes. We may be looking at the briefs or arguments that someone has made. We're looking at some other thing, but all of that is done to really help us understand and assimilate what is being said. And we just want to be sure all of you are make clear to all of you that as we do that, we're not being distracted from the argument. We are listening to the argument, and hopefully that task helps us process the case. So with that explanation of kind of how we proceed and what you might expect today, I will ask the attorneys to come forward in 124169, Alex Fisher versus Department of Revenue. Ready? You may.
May it please the court. The question that appellant poses for this court today is whether or not the Court of Appeals erred in finding that there was subject matter jurisdiction in this case where the DC 27, the document that, as the Court of Appeals has stated, gets the ball rolling in a driver's license administrative hearing, whether the errors in that, in fact, failures to comply with statutory requirements in that document, divested the administrative agency and therefore every other court thereafter of subject matter jurisdiction to suspend Mr. Fisher's driver's license. The requirements of KSA 8-1002A are certification requirements that have been listed in the statute for a very long time. But in addition to those, there are additional requirements at 8-1002D as in dog that includes that the certifying officer must state the date on which the notice was served to the licensee. And by virtue of that, that also informs the licensee of the date on which his license will be suspended absent a request for an administrative hearing. They don't fill in that date twice on the DC 27 form, which is a form that was created by the department to help their officers to comply with the requirements of 8-1002. But they use that date and then say the effective date of the suspension will be 30 days after the date of service. In this instance, it's undisputed that Mr. Fisher was stopped and had this police encounter in 2019. However, the DC 27 at both places where the officer fills in a date, paragraph 1 and paragraph 8 regarding the date of service, the officer filled in April 25th, 2019. Inexplicably, somehow, by the time that document became a part of the record, which it's volume 2, in the answer and agency record for this court is volume 2, page 5. Someone has corrected both of those dates to say August. It's still unknown who made that correction, whether it was a police officer when he submitted it, whether it was someone at the department who was reviewing it, which they're required to do pursuant to 8-1002F, or some clerical person. We just don't know the answer to that, but it's undisputed that it said April when it was served on Mr. Fisher and that the date in question actually was August. These courts, the appellate courts have decided that the wrong date in item number 1 is not a jurisdictional issue. They decided that in the Schmidt case, they decided that in the Felgate case, but in each of those cases, the court said, well, subsection A doesn't require the date of the incident. And then they went on to say the date is required in subsection D. That was dicta because that was not what they were addressing, but it was sort of like the wrong date in paragraph 1, date of the incident, doesn't matter. And then the court sort of said, it's not like it was the wrong date in D, which is required. So each of those cases, we believe, supports our position that the correct date in paragraph 8, which is what is required by 8-1002D, the date of service and the date on which the suspension would become effective, absent an administrative hearing, that is jurisdictional.
Counsel, do you agree that subject matter jurisdiction, as it applies to an agency like Kansas Department of Revenue, references the authority or power to act of that agency to act?
Yes, Judge and Justice, sorry, we believe that all of the agency in this case's authority act comes from 8-1002, where it says that proper certification of the items listed in the statute, the statutory requirements, is essentially what confers jurisdiction and authority upon the agency to suspend the driver's license, that it's purely statutory, not constitutional.
So it's important to determine whether or not the legislature has given the Department of Revenue the authority to act in this instance. And in KSA 8-1002F, it states upon receipt of the law enforcement officer's certification, the division shall review. Doesn't that phrase, the division shall review, presume the legislature has given the Department of Revenue the authority to act?
Well, what it goes on to say is that the division shall review the purported certification for any obvious errors or factual discrepancies. And if they find those, they shall dismiss any suspension.
They shall make a determination that it should either proceed, the proceedings should go on, or the proceedings should be dismissed. Isn't that action a statutory interpretation using their legislative authority to act?
I understand the sort of quandary, Justice Wilson, and that is, right, to follow their statutory mandate to dismiss a case where the DC 27 or the officer certification doesn't comply with the statute. I guess you're saying, well, in order to be able to dismiss it by their statutory mandate, they have to assume jurisdiction of the case at that point. I guess our position is, because B of that same statute, 8-1002B, says the only thing that confers upon them jurisdiction or authority to act is receipt of a proper certification. And so F is where they determine whether or not they have received a proper certification.
And doesn't
if-
F only require compliance with subsection A? Doesn't say anything about subsection D. It just says if it complies with subsection A, the license shall be suspended.
Yeah, our position is that these other cases that have said, and Schmidt's one, Felgate's one, those are the ones really, probably the Stutzman case also deals with compliance with subsection D. You're correct, Justice Siegel, that it says if it fails to comply with A, they shall dismiss it or should dismiss it. But if you look at these other cases, in the case of either a failure or a refusal, those cases say other information that is required on the certification is contained at D, and that's the driver's name. I mean, I guess I would propose to the court, what if they send it in with a driver's license number for one person and a completely different name? How is the clerk or the admin person at the Department of Revenue to determine whether that's factually?
And it could still be,
inaccurate.
the suspension could still be an error without the agency being deprived of, as Justice Wilson said, the power to act.
Right.
Isn't subsection F what grants the agency the power to act?
I believe it's B that grants them the power to act.
Well, that talks about the completion of the certification. F is the subsection that talks about what the agency does when they get the certification.
Right. F confers upon them the authority certainly to dismiss a non-compliant certification.
Or to suspend driving privileges. That's what it says. It says shall proceed to suspend driving privileges.
Right.
Once
Along
they
with the
determine
procedure
that,
that-
once they determine that it complies with subsection A.
Yes, absent the hearing that is obviously
Sure,
a due
sure.
process issue for the driver.
You keep referring to subsection B, and I've got it in front of me, and I don't see the language that confers anything other than it just says certification shall be complete upon signing and no additional acts of oath, affirmation, et cetera. And then the certification shall be admissible. And I don't see anything that directs or permits the agency to act on anything in B.
The language that I am referring to, it says receipt of any such certification, copy or reproduction shall accord the department authority to proceed as set forth herein. So it's our position that it is subsection B that accords the department the authority to move ahead.
And I just don't see how that, this gets back to the questions you're being asked. I don't see how that hooks subsection D into anything, particularly when F is so plain. F is very plain. It says that, you're authorized to suspend if subsection A is met, and you don't make any complaint about the information required by subsection A.
Do not. And our issue before the court isn't necessarily that someone, whoever it is that reviews this document at the department, messed up by not dismissing it pursuant to F. And that is something that the Court of Appeals, I think, the very last line of their opinion, that's one of the things we would argue that they got wrong. The last sentence, which is also the last full paragraph of the opinion, says, since Fisher only challenges KDOR's authority to suspend his license and not the reasoning of its decision to do so, we need not address whether the KDOR should have dismissed the case because of the mistakes on the DC 27 form. I think they're referring to sort of an argument that they should have dismissed it pursuant to F before we ever got to this place. But the Court of Appeals reasoning that we didn't argue it right at the lower court levels, and this is something that's in my petition, and frankly, a question that drivers across Kansas need an answer to, right or wrong, and that is, if 8-1020H tells the licensee, these are the only things you can raise at an administrative hearing, and wrong date of service is not one of those, and there are many cases that say on judicial review, you can't raise things you didn't raise at the administrative hearing. Where then is a driver supposed to raise the issue of a wrong date of service? Failure to comply with 8-1002D is not something that's allowed to be raised in administrative hearing. So we're left with no remedy if they put the wrong name, if they put the wrong driver's license number, if they tell me the wrong date of service, if they leave it blank, if they put words there that aren't even found in the English language, they just fill in a series of numbers and letters for the date of service on number 8, we would have no remedy.
Well, counsel,
Well, let
that's
me-
not exactly right, though, is it? Because KSA 8-1020P states that those things that would apply to constitutional issues, such as due process or any search and seizure or inappropriate manner in which the highway patrolman conducted himself, all of those things can be raised before the district court under P, can't they?
I don't know that countenancing this wrong date as a due process issue is, we saw it better as a jurisdictional issue, that it's not proper certification if you don't comply with the statute. They didn't. And who's to say whether that's just a minor error or the Court of Appeals couched it as a clerical error?
Well, you have to request an administrative proceeding within 14 days, right?
Correct.
So for example, if the service of the certification was inadequate, the name was wrong, or some mistake was made, and he waited more than 14 days to file an appeal, wouldn't those things be considered by the administrative hearing officer to determine whether or not the late appeal should be considered anyway?
I guess that assumes that everybody would look at that document and say, this is clearly wrong. In our case, for example, they received it, it's file stamped, the one that's in the record, on August 30th of 2019. And it said April 25th is when my client was served. So by the date of service, he should have requested a hearing by May 9th. And if they got his request for hearing on August 31st, his request is not timely. But because they all said, surely the police officer meant August, not April, we've fixed this, then it's timely.
Well,
But-
your client filled out an affidavit that he was actually served on August 25th, and didn't the officer admit that was true?
Yes, but I was trying to sort of get to the court's example. If this had instead of something so blatant as August versus April been, let's say he's actually served on August 25th. but the officer wrote August 15th. That would make then his request due on August 29th. But our client knows he got it on August 25th, and he goes and takes him a few days to get counsel, then counsel sends him a request for hearing, and it doesn't get filed until August 31st. The department, just looking at that, doesn't know that's a wrong date. So they would believe then that his request was untimely.
And you're presuming a prejudice that did not occur in the case of your client, correct?
Right, and it's our position that when we're dealing with subject matter jurisdiction, I don't believe that we need to show prejudice. But I would agree, he was not prejudiced by this
And
error
that's-
date,
can I
except
ask-
having to be here.
Can I ask you a possible statutory construction that arguably could incorporate the requirements of subsection D into the subsection F analysis by the Department of Revenue? So subsection A2 does say that or requires certification that the officer had presented the person with the oral and written notice required by KSA 8-1001 and amendments thereto. Actually, that's 8001. What are those requirements?
Number one,
Yeah, in
Um,
1001 as opposed to 10002.
Isn't
What-
that the DC 70?
1001 is the notification aspect where the court is divided between certification and notification. So that you don't have a right to refuse testing, all those sorts of notices.
Okay.
And yes, the DC 70, Justice Wilson.
Yeah, I had confused my subsections here, so that answers my question. Thank you. I'm sorry.
There's statutory construction, looking at your, as I understand your argument in B. Or your, looking at the language of shall accord the department authority to proceed as set forth herein upon, and so that's upon receipt of such certification. So for such certification, do we look back to A? Finds the certification required by this section shall be signed by one or more officers to certify, and then has paragraphs 1, 2, and 3. That the such certification that B is.
I would argue it's the certification that meets the statutory requirements, which includes subsection D.
Where are there other, I'm not finding other places where it refers to certification. Am I missing something?
No, he's
It's
required
all in A or that reference in B.
required to certify also by signing, and the absent signature with regard to requirements of A and D was something that the court found to be error in the Stutzman case. That was one where the department argued that he just didn't write hard enough on the carbon copy. And so he really did certify these things, but none of them were certified on the copy that was presented to the licensee. And the court found that jurisdiction was lacking because it was not certified as required by A, B, and D. So we argue that certainly judicial interpretation of what's been required includes the requirements of subsection D for it to be a proper certification. You can't certify falsely and say, this is a good DC 27 I'm giving the department. We're not alleging that this officer was intentionally false here, but it wasn't true. So it was false.
Does use the word certification.
I think that's the certification signing. Yes.
Other questions?
Thank you.
May it please the court, New Win on behalf of the appellee, Kansas Department of Revenue. In this case, on the DC 27, we would like to point out that this mistake that was on the DC 27, which was the date that was incorrect, was not an obvious mistake. And in, I believe, Sandate, the court stated that the Department of Revenue reviews the DC 27 form for quote unquote easily discernible errors like missing signatures or check marks or factual discrepancies. When the Kansas Department of Revenue received this DC 27 and then received a request for hearing, we allowed that hearing to be set and heard. And the appellant makes an argument that there is no way that the licensee would be able to argue that there's a they would not be able to have a remedy due to not being able to argue this discrepancy at the administrative hearing. But as Justice Wilson had stated, KSA 8-1020 subsection P gives the allowance of the district court to hear that type of issue if necessary. The appellant also argued using Wall, Stutzman, Felgate, and a couple other cases in regards to DC 27 issues. And we would like to point out that in Felgate, as in this case, there was no prejudice shown. And the court stated in that case that when a law enforcement officer fills out the notice informing a driver he or she failed a breath test, the time or at least the correct date of the incident is not of the essence. And so we would, as the Department of Revenue, say that because the dates were incorrect, justice was still served in this. There was no prejudice to the appellant in this case, in that this mistake on the DC 27 did not deprive us of jurisdiction to make a decision on this issue.
Bill's made a reference to both state and constitutional. There's no constitutional referred to your agency. Your agency has to get jurisdiction to suspend this license only from statute, right?
I believe so. That would be found in KSA 8-1001. And
Right, but there's nothing flowing from the Constitution that gives
No.
the division authority to do anything.
No.
actually.
not in this case.
Yeah, it's just an odd reference that the Court of Appeals used. Something that probably needs to be cleaned up. Statutory, so now the question is whether the statute kicks jurisdiction because the officer made a mistake on this date.
And we would also say that it would not be the legislature's intent if there was a simple mistake, like in this case where a date is incorrect, that we would have to dismiss the case, and it wouldn't be in the best interest of the public safety to have possibly drunk drivers on the roads. Just because,
Isn't the question, the fundamental question is, did the agency have the power to suspend this driver's license?
yes, and I believe that this, sorry.
This may be a semantic question, I don't know, but Justice Bowles' question just sort of tees it up for me, so I'll ask. Is jurisdiction even the right conceptual lens to look through which we should look at this? Because that's typically a judicial, I mean, it's a concept that we apply to courts. And here we're talking about the executive branch.
Yeah, I would say that perhaps the appellant should have argued more of a due process issue.
Well,
Or-
I'm asking kind of a higher level question, because at one level, it may very well be semantic. In other words, we're asking about the power of the agency.
And the power of the agency comes from statutes. So I guess having reviewed all my arguments with my briefs, I've stated the statutes and the cases that would help our arguments. I would just say that if for some reason that the Kansas Department of Revenue did not have subject matter jurisdiction, to make a decision on a DC 27. I just have an issue with how are we supposed to make a decision on a DC 27 if we have no jurisdiction to make that decision itself? If we have subject matter jurisdiction to review the document and then somehow it's taken away from us, even though on the face of the document itself, there's no crucial missing information such as a driver's license number or a name, as suggested in the petition for review from the appellant. That would just be a preposterous case because we wouldn't be able to serve anybody with a suspension at that point. And even if the appellant's argument that the driver's license and the name didn't match, in order for us to even notify somebody, we would have that information in our system and have to check that information. And if it's incorrect, then we wouldn't be able to suspend anybody at that point. But here it's a date on a DC 27 that at the time we did not know was incorrect. We gave the administrative hearing, the driver's license holder came to the administrative hearing, arguments were heard, a decision was made. Then it went to district court and the same argument was made where the district court found that jurisdiction did exist for the Kansas Department of Revenue and therefore the courts to make a decision on this argument.
That where 81002F comes in. Instructs that the department has to review to see if not, it must dismiss, but otherwise it may proceed. Is that your suggestion that being able to proceed shows that there's continued subject matter jurisdiction?
Yes.
Is that what? I understand your argument. Okay. So.
Yes, Justice. And also I would say that the ability for Kansas Department of Revenue to hear these cases with the DC 27 is conferred in section 8-1002, but also 8-1020 speaks about what would happen at the administrative hearing. And so I would say that that also confers the Kansas Department of Revenue some jurisdiction to hear a case derived from a DC 27. I have no further arguments, justices, unless you. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement. What that means is that later today, the court will begin conferencing this case and we will continue to have discussions between the six of us. One of the justices will be assigned the assignment of writing a decision in this case. It will be reviewed by all of us as we work through the language that we would all approve, or if we can't reach approval, have separate opinions written by some of the justices. When they solve all of that, the decision will be in written form. It will be filed on our kscourts.org website as well as published in other places. And a press release will be issued that will give notice that this decision has been. So you can watch for that. Parties, of course, will receive written copies. So thank you to both of you. Now call forward the attorneys in case number 122660, State of Kansas versus Ron Richard Larsen.
Please support counsel. Corey Call representing Ron Larsen. I would request 3 minutes for rebuttal, please.
3 minutes is granted.
Mr. Larsen was convicted of several crimes from Johnson County. This court granted review on 2 issues related to one of those, an attempted aggravated burglary. And the relevant facts is that Mr. Larsen was involved in some burglaries in the area. He entered a fenced-in backyard. Mr. Tinsley walked up to the window, looked in, Mr. Tinsley was watching TV, Mr. Tinsley got an alert on his phone, saw that got a picture of Mr. Larsen standing on his back patio. Mr. Tinsley went upstairs to get his gun, came back down, and Mr. Larsen was gone. And the state charged him with attempted aggravated burglary. And so we have two issues this court granted review on. One was whether the walking up to the window was a sufficient overt act. And the second is we're asking this court to overturn State v. Watson, which stated that on an attempted aggravated burglary, the state does not have to prove that the defendant specifically intended that there be a person in the house. Whether they would only have to prove that they intended to burglarize the house and that factually there was someone in the house. So the first issue is whether we have an overt act of walking up to the window. As always, it's good to start with the statutes on those. And so an attempt is defined as an attempt is an overt act towards the perpetration of a crime done by a person who intends to commit such crime, but fails in the perpetration thereof or is prevented or intercepted in executing such crime. That definition has been qualified to note that the overt act towards the perpetration must necessarily extend beyond mere preparations made by the accused and must approach sufficiently near to the consummation of the offense to stand as either the first or subsequent step in a direct movement toward the completed offense. So again, here we're talking about walking up to window and looking in the window.
Can we go beyond just walking up to the window and looking in, and what the other evidence supported the burglary or the aggravated burglary, the text messages that he was sending, other communications that he made at the time? Does that enter into the equation when we look at this?
I think those are highly relevant to what his intent was. So, and there are two parts of it. He has to commit an overt act, and he has to commit an overt act with the intent required. And so I think it's very important to understand that he had the intent to commit a burglary. And I'm not standing up here saying that at trial they did, but for purposes of this hearing, he walked up there with the intent to commit a burglary. But because mere preparation is not enough. If he was merely preparing to burglarize the house, well, he likely still has the intent to burglarize the house. That's why he's preparing, right? Is that he's intending to do that. And so there was a lot of evidence about his intent. And I do not believe that should color the intent, unless the only thing would be is if he did something. There's a case where they took off the air conditioner, right? Which would be an overt act, unless maybe there was some innocent explanation. If he had some innocent explanation as well, that wasn't. But again, that kind of goes to intent. I think the overt act has to stand essentially on its own. I mean, you understand that this is why he's doing it, but it has to be an overt act beyond mere preparation. And as I said, the intent is he's going to have the intent to commit the burglary. That's why he's preparing.
Seems to me the two arguments you're making are at cross purposes with each other. And the reason I say that is because you really want us to believe that he did not intend to burglarize an occupied house. That's the attempt, that's the whole fight about the attempted crime. Seems to me that it's an overt act if you intend to burglarize an unoccupied house to take a look and see whether it's unoccupied. And that's not preparatory to me. I mean, that's actually looking in to see whether I can do what I intend to do. And so it seems to me I get past that. Now, where am I wrong?
Well, here, and I think this is something that I think we struggle with. And it's one of the nice things about being on this side of the bench there is that I get to point out sort of the difficult things, and you all have to maybe resolve the difficult things. And one of the difficult things in looking at these cases is that everyone agrees this is what the law. Mere preparation is not enough, and you have to have an overt act towards perpetration. But then there's very little analysis about where one ends and one begins. And so we end up with just sort of, and I understand what you're saying. It's sort of the conclusion. I say, no, it's looking in is a preparation. That's he's casing the joint. He's reconnoitering, as they said in some of the cases, that he is preparing because to actually he hasn't begun the process of burglarizing. Which I guess if I asked you to draw a line, that's where I would say you have to draw lines. You have to begin the process of burglarizing. That if you're preparing, if you're deciding, is this a good house to break into? Do I want to go into this house? You're still in the preparatory stage. You're intending to burglarize, but you haven't actually attempted to burglarize. And I think
Is it preparing to burglarize if you jiggle the doorknob to see whether the door is locked or not? Is that still preparatory in your view of things?
I think at that point, you are actually taking some part of the actus reus of entering the house. You jiggle the doorknob, you test the window to see if it's open. You are actually attempting to enter. I mean, I think this court talks about using common language so that people understand it. I think that's important. And I think, and again, this is sort of me, I'm making the same conclusory problems I'm complaining about the court. But I think if you ask somebody, a guy walks up to a house and looks in the window. Guy wants to go in a house. He goes up, he looks in the window. Has he attempted to enter that house? I think most people would say, no, he hasn't attempted to enter the house. If you say, hey, guy goes up to and he jiggles the doorknob to see if the door is open, has he attempted to enter that house? Well, yeah, I think more people would say yes. I think that is. I think it's important these common sense interpretations of, because jurors have to make these decisions, right? And we have to have. Honestly, I'm not sure I know where the line is, or I can't even get close to the line of where an overt act of preparation versus an overt act of perpetration. Where do those? Where does that line end? And I think it's important to draw that line. And I think it has to be something that you are you're beginning the process of the commission of the crime.
And hasn't through case law, our court backed that up to the point where you are on the property in essence? I mean, with a couple of the cases where if you've entered the backyard, and I think one of those cases drew a line by saying you've moved from gathering the burglary, the equipment, you know, it's not like you're grabbing the flashlight or the picks or whatever it might be, but you've actually taken an action where you're entering somebody else's legal property. Is that a legitimate line between preparation and overt act?
I guess I don't think so. And I think because burglary itself does not concern itself with the property line or where that is. The burglary is the entering in the house. When have you begun? When have you attempted to enter the house? Because that's what we're talking about, right? When have you attempted? And I don't think that saying that, yeah, once you walk on the property, you have attempted to enter the house. There's cases that say that, although the most clear one was the case I was talking about where they took the air conditioner off. So I'm not sure the court had to get to enter the backyard, but nonetheless, I think what we're talking about is that, and I think the language of that talks about the mere preparation, so it must approach sufficiently near to the consummation, which I looked up and means completed, the completion of the offense to stand as either the first or subsequent step in a direct movement towards the completed offense. Both of those that they're talking about doing something towards the completed offense, as opposed to where it seems like coming on the property. It's like, well, if you get close to starting to commit the crime, then that's beyond mere preparation. And that's not what this language seems to say. It's if you get close to take the first step towards the completion of the crime. And I think in the burglary context, that is some attempt to enter the house as opposed to just approaching the house.
Well, it seems to me that you're arguing this is just a finding of fact for the jury to make. And didn't they make it?
Well, it is a finding of fact, but as with all findings of fact by the jury, there's a floor which we can't get below. And if the legal definition of mere preparation involves is just going, if going on the property is legally mere preparation, is legally insufficient to be an overt act, then a jury can't make that finding of that. Now, a jury can say, once you try and get into the house, did they try and enter the house? Are there actions such that they attempted, whatever they did was an attempt to enter the house? But I don't think anyone can say that walking up to a window is attempting to enter the house.
And
At that point, it must be a question of law.
At that point, it is mere preparation, which courts have said as a matter of law is not an attempt.
And I think it's more of a record question for me, but the jury was instructed on the overt act here, and was that limited to looking in the window?
Yes, the instruction, the element said overt act, to wit, looking in the window, and in closing argument, the prosecutor explicitly elected the one we're choosing is looking in the window.
And maybe this is a different way to, as I'm understanding your argument, that evidence that might be sufficient to support the overt act for burglary might be different if then this evidence that would be sufficient to support an overt act for aggravated burglary.
Well, are you segueing me into my second argument?
Well, maybe.
I think as I understand it, the overt act to commit a burglary, I think would, I guess, if I say it like this, all evidence sufficient to support an act for an aggravated burglary would support an overt act for a simple burglary. But
not vice versa.
Not vice versa. No, I don't, because an element as an attempt is any overt act towards the premeditation of a crime done by a person who intends to commit such crime. And so this court has interpreted that to mean that any attempt you must have the specific intent to commit whatever crime is attempt. So here, aggravated burglary.
Can I ask you about that?
Yeah.
Real quick. Isn't the aggravated part of aggravated burglary strict liability? In other words, there is no, in the aggravated burglary statute, there is no need to prove intent on the aggravated portion.
That is correct. That is absolutely correct. And I think the Court of Appeals, okay, well, I guess, is there a follow-up? Because I gotta agree with that.
The follow-up is then why would since aggravated burglary contains no intent component to the presence of a person, how does the attempt statute add that in? That doesn't follow to me.
Okay, because the attempt statute says that you must intend to commit such crime. So you have to intend to commit that crime. And
what about the reading of that basically that interprets that language to mean you have to have the same intent as the crime that you're being charged with an attempt of?
No, I guess I don't see that. If you intend to, a person who intends to commit such crime.
Yeah, let me just follow up by saying there is such a thing as just pure strict liability crimes. Your argument would be that you can never, as a matter of law, you can never attempt a strict liability crime.
Unless you intend to commit that strict liability crime. And so.
Does that even make sense to talk about an intent to commit a crime that has no intent component?
Well, I think it does, because what we're punishing with attempt is, I mean, obviously there's an overt act, but what we're punishing is what you're trying to do. What crime are you trying to commit? And because we don't punish this, we don't change the severity of attempts based upon the consequences of that crime, or based upon the
But we do with burglary. That's exactly what we do. In other words, all you have to prove for burglary is the entering with an intent to commit a felony. And if you're just unlucky, quote unquote, that just a person happened to be sleeping You know, we
Yeah.
have instances where there's a burglary of a warehouse and there were homeless people perhaps camped out, and it's like tough luck. That's aggravated.
Absolutely. And we do that with completed crimes, but with aggravated crimes, I'm sorry, with attempted crimes, we vary the severity level based upon what you intended to do, what your intent was of that crime. And that seems to be what the statute says. And with the recodification, 215202F says that if it doesn't, if a definition of crime prescribes a culpable mental state that is sufficient for the commission of the crime without distinguishing among material elements, such a provision shall apply to all the material elements of the crime. And so under that subsection, it seems to me that they say if you intend to commit such crime, that's a specific intent as to the elements of that, it would apply to all of those. A G does not change that. I think G is what we were talking about, such that you have, so G would apply. If I was trying to argue that aggravated burglary, you need to, because it says specific intent in the statute, you need a specific intent to commit a felony. Well, that specific intent applies across the board. And so for aggravated burglary, you need to have a specific intent to that there be a person. But G says that if there's a culpable mental state with regard to a particular element, then that would it doesn't apply to the other sections. And so I think I help my daughter sometimes with her math homework and she's in algebra. And so I think of it as you gotta work, they come, you gotta work them in, right? And you think of it, you have the distributive product, we have the coefficient on the outside of the parentheses. So you have 3 times 2x plus 4. Well, it applies to each individual one, and that's kind of how I see this, as opposed to, because it says it applies to the whole crime. And when they wrote that into the aggravated burglary statute, I think they didn't want the specific intent to go to that a person is present for the aggravated burglary, but for the intent, you have to intend that whole crime. And so it applies to all of the elements.
Yeah, let me get to a slightly different scenario. What if it was something else in the backyard that startled your client and he decided not to enter the dwelling, to burglarize the dwelling, and it's occupied? Is that an attempted ag burglary in that circumstance?
Oh, I mean, so if he didn't actually see the guy.
If he didn't see the guy.
Right, well, no.
And for some other reason.
Unless the state can prove that he intended that there be somebody in the house. And
What it takes?
that he has to.
Intended to have someone in the house?
Yeah.
So if you enter, that's not how aggravated burglary works.
That's not how aggravated burglary.
Just how Justice Stegall pointed out, that if you don't have to know someone's in the house to commit an aggravated burglary. So what's the difference?
Well, because on an attempt, you have to specifically intend whatever crime you're attending. An attempted burglary requires someone to be in there. And so if you're attempting an aggravated burglary, you have to intend the elements of aggravated burglary, one of which is that there's a person in there.
Under the unique facts this jury had, where they knew about the Mason incident, where we had people who were in the house, but presumably possibly could have been thought to be asleep, and some were. Could a reasonable inference a jury would make here on it? So looking back to your core of your sufficiency, even if we accept your argument that the jury could have believed there was an intent to enter a house, even if there were people present, just not if they were awake where they might catch them. And here he had someone who he realized was awake, as opposed to his other pattern of going ahead and entering a house at a time of night when it was likely to assume people were in bed asleep.
It seems to me that what you're talking about is the mental intent of knowingly. That if you go into a house at all the lights are off, 2 a.m, you know or should have known that there's somebody in that house. But that's not the intent we're talking about here. We're talking about an intent to go in, which you have with burglaries, when you go in to commit a battery. You're going to go into a house, I'm going to break into his house, and I'm going to beat him up. Well, you're intending that there's someone be in the house, or a sexual battery, or those type of things. But the answer to your question is no, I don't think so, because that sounds more to me like a knowing intent rather than an intent that there be someone in the house. Unless they could show that he did want them in the house for, he liked the excitement. He only wanted to break into, his mode was to break into houses when, because he liked the excitement or something like that. But absent those strange facts, I would say no.
So you would define, are you, in the attempt statute referring to such offense, you would say that's the charged offense?
I would say that is the offense that they are charged with attempting. That is correct.
Not like this where we have a core offense of burglary, but you could also have battery or something else. You're not looking at that core, you're looking at the actual charge.
That's right. That's right. And the legislature could make a crime of aggravated attempted burglary, right? If you attempt to enter a house where there is a person in it, then they can do that if they wanted to make that a crime if they wanted to, but that's not the crime that we have. Thank you.
Chief Justice, and may it please the court. I'm Jacob Gonteski. I represent the state of Kansas, the plaintiff, the appellee in this case. Ronald Larsen entered the backyard of the Tinsley residence with a bandana on at night and peered into that window, taking an overt act toward the perpetration of aggravated burglary. That's what he was there to do. He sets it forth in his text messages to others. It's shown by his other burglaries that were conducted in the same sequence. And the jury heard all of this information and properly considered all of it in the totality when they evaluated that stepping into the backyard and peering in the window constituted an overt act.
For any of the, I don't recall, were any of the other burglaries, aggravated burglaries where there were people?
They were.
Structure.
They were, yes. He was in this same case, along with this attempted aggravated burglary. The other convictions that he was that he was found guilty of by the jury included one aggravated burglary and a kidnapping that occurred in that house in the 2 days after this one. So there was another circumstance there. And specifically in this petition for review, opposing counsel was not specifically attacking just the overt act of looking in the window. Specifically in the issue that was granted review here was the argument that the Court of Appeals incorrectly considered Mr. Larsen's intent to commit a burglary when it was evaluating whether or not there was sufficient evidence to find that he conducted an overt act. And my response to that is that they absolutely were permitted to look at his intent when considering whether or not he committed an overt act. And his intent was relevant there and is part of the totality of the circumstances that both the jury properly considered and that the Court of Appeals considered, because the act of looking in a window can in and of itself at times be a result of innocent behavior, non-criminal behavior. Somebody could do that without it being an overt act toward the commission of an aggravated burglary. A friend could arrive at a house to pick somebody up, thinking they were supposed to be there and ringing the doorbell and not finding anyone home, could peer in the window to see, where's my friend? I'm supposed to pick him up now and I can't see him. I wonder if something's wrong, and could peer in the window and see if he could see anything in the house. That's not an overt act toward the perpetration of aggravated burglary. That's just a concerned friend looking in the house. But here, in considering whether or not the peering in the window constituted an overt act, both the jury and the Court of Appeals properly considered the context in which looking in the window was done. And that's justified here. Furthermore, the looking in the window was not mere preparation for the burglary. Preparation for the burglary may have been Mr. Larsen at home gathering his gray bandana that he wore to all of his burglaries. Or it may have been finding out how he's going to get to that house. or clearing off his calendar, making sure he's off work that day, whatever it might be, that's mere preparation. But you pass from mere preparation toward an overt act and you arrive in attempt land when you take yourself to the scene of the crime that you're looking to commit. When you, as Mr. Call put it, when you case the joint, that's an overt act. And there's a wealth of case law beyond Kansas that says
The overt act for what? Isn't that the question?
it is.
Is the overt act to commit a burglary or to commit a burglary in an occupied dwelling?
Either one.
Why is it an overt act towards the aggravated aspect of this?
It's an overt act toward the aggravated aspect because in the full circumstances, when we look at all of Mr. Larsen's behavior, which the jury did here, we can see that he enters occupied homes.
So it's fact specific to the text, to the other the context of the other crimes that were charged, not to the behavior on this night.
Well, here, you need not get to that point of whether or not it was either one, because there's so much evidence that shows both, that satisfies both. But it could be shown here that this was sufficient to show that he attempted an aggravated burglary, because on other nights he committed aggravated burglaries. He looked in the home. While one inference could be made that he was looking in the home to see if anybody was awake downstairs that would intercept him, another interpretation of looking in the window could be to see if there was anything in there that he wanted to steal. Because in the other aggravated burglary that he committed, a purse was left on a table near a window in the back of the house.
Let's change the facts a little bit, just so I can understand the state's position on the statutes themselves.
Yes.
If this is a case with very similar facts, guy comes to the back door, back porch, looks in the window, sees somebody, runs away, essentially. But there's just overwhelming evidence, and maybe the state doesn't even contest this evidence, that this is a very careful burglar. And he works very, very hard to never enter structures where people are present. And that's just overwhelmingly clear. Nobody's contesting that. Is this still an attempted aggravated burglary?
I believe it would be, although
Why?
that's not what we have here.
I know, but it's important to understanding how these statutes work.
Understood. Because when I look at the argument that is being made, that you can graft specific intent to every element in an attempt. The Mora case from last year from this court is the case that opposing counsel relies on for that proposition. But the Mora case was evaluating aggravated robbery, and aggravated robbery is a crime of general intent. And the attempt statute, by requiring that the defendant have the intent to commit the underlying crime, essentially grafted on to his attempted aggravated robbery in Mora that specific intent that was lacking in the statute. But in the aggravated burglary statute, we already have a crime of specific intent. This is not a crime of general intent like the aggravated robbery in Mora. This is a crime of specific intent. This court has said repeatedly that aggravated burglary is a crime of specific intent. So the attempt statute itself does not graft on an additional element of intent or an additional component of intent, because the aggravated burglary statute already has specific intent within it.
Would interpret the statute to mean that you simply have to take an overt act with the identical level of intent as the underlying crime.
Precisely. That's the clean rule. That's the simple rule. That's the same rule that's applied by this court in accomplice liability. When we establish accomplice liability, then we have to establish that co-defendant has the same intent as the accomplice. And that's a logical analysis of it. It's not logical to graft onto an attempted aggravated burglary that they must intend to go in knowing that there are people inside. The reason
in Mora, there's a citation to and a quotation from a Ninth Circuit court that I think explains the thought process behind actually adding an intent to the attempt statute, which is that if you have a completed crime, it's there's intent can be inferred. But if you don't have a crime, you don't have that. And because of that uncertainty of proof, there has been a requirement of that higher level of proving the intent to commit all of the elements. Does that counter what you're saying?
I don't believe it counters what I'm saying any more than what it does is establish that the overt act of looking in the window satisfies the circumstances here, because when we look at the totality, we see that peering in the window was not an innocent act. So I don't believe as though the attempt statute in Kansas grafts upon the aggravated burglary, the attempted aggravated burglary crime, an additional level of intent or knowledge. I believe as though it is already satisfied if the state can establish that he intended to enter the residence to commit a crime. And that intent was present here.
If I oversimplify your position, say that this notion, Mora's talking about such crime and whatever that may mean, whether you have to have specific, prove specific intent. Is it oversimplifying to say you really don't care in this, that it doesn't matter which path were true because you had enough evidence to show, what would it affect be the more strict interpretation that the defendant is? So we don't have to decide that question. It could be either one. You just want us to say there's enough there if it is the higher level.
At its core, this is a sufficiency claim after all. And my argument would be there is essentially super sufficiency here, that either one is satisfied. I still don't think this court should find the rule or should hold that the attempt statute grafts on to aggravated burglary an additional level of intent that the state must prove the defendant intended there to be people present inside. I don't believe as though that should be this court's holding, but even if it did hold as much, that's satisfied here by the facts here, which include the other aggravated burglary for which this defendant was convicted of, that had the kidnapping as part of it.
Was
So-
this nuance of having to have the intent, people being in the house argued to the jury?
I don't believe it was. I believe everyone in the trial court, when this case was tried to the jury, understood that the only requisite intent that was required for the aggravated burglary or the attempted aggravated burglary was the intent to enter the residence. And
Preservation problem here, or that come into the, I know this is a sufficiency, which we usually don't deal with preservation, but there is this question of law. Did that need to be preserved?
I think there's a reasonable argument that it should have been preserved before it got here. Especially given the fact that I'm here and I can argue the super sufficiency in effect, because there was no need at the trial court to parse that out because the argument was never made that his level of intent was insufficient to satisfy the attempted aggravated burglary. So that he has not preserved this claim, so to speak, at the trial court, I think would be a logical conclusion of this court.
But not an argument you've made.
Well, it's not one that my colleague advanced in the brief, so it's not one that I'm prepared to advance here today. When evaluating the intent required of an aggravated burglary or an attempted aggravated burglary, opposing counsel offers this court a pair of hypotheticals that he argues under existing precedent is incongruent. If this court reads Watson, and I would note for this court, when the parties are discussing Watson, the 1994 case, which concluded that the state need not prove the defendant knew somebody was present in the aggravated burglary, Watson actually relied upon another case of this court from 1974, which essentially said the same thing. So we're going on 49 years now of this court holding that the state need not establish the defendant's knowledge or intent that a party was present in the home when they committed that aggravated burglary. That would all need to be overruled to find for Mr. Larsen in this case. But he argues this pair of hypotheticals that he says shows the incongruence here, where he says, if wanting to break into an empty house and steal something inside gets punished more harshly simply because there happens to be somebody inside, That's incongruent with the case that we don't have here, he argues, which is wanting to break into a home to commit a sexual assault inside, but then in so doing, finding there's nobody present. And he argues that by his client, Mr. Larsen, being convicted of the first of those two scenarios with a harsher penalty because there was somebody inside is incongruent with the purpose of the statute. But I would argue just the converse, that breaking into a home, even if you only have the intent to commit a theft inside, if somebody happens to be inside, that crime should be penalized more harshly. And the rationale is the same rationale the legislature used in finding the separate crime of aggravated burglary to be a higher severity crime. And that's because of the potential of a conflict arising from somebody confronting the burglar in the house. That potential for conflict is what is more severely punished in an aggravated burglary. And that potential for conflict need not be because that was the defendant's intent when they entered, was to create a conflict. But if they conduct themselves in a manner in which that conflict has the potential to arise, then they have committed more serious conduct, a more serious crime than that of a simple burglary. And that's why the policy rationale justifies the discrepant penalties in those two hypotheticals that he offers. But even all of that said, these are really policy arguments that rather than before this court are properly resolved on the other side of 10th Street. Those are policy arguments that are made by the legislature to the legislature when they're crafting these statutes. It's for these reasons that I would ask that you find Watson and Price before it are still good law, that the state established sufficient evidence to prove Mr. Larsen was guilty of attempted aggravated burglary in this case, affirm his convictions and his sentence. Thank you.
Paul, you reserve 3 minutes. Thank you to both counsel. The court will take this case under advisement. Court is now in recess until 10:30.
All right.